So I think we'd completed till malicious prosecution. So we'll be starting with negligence today. Now, negligence is a very important tort in the sense negligence basically is a situation where a person has failed to do something which he or she was otherwise was under an obligation to do. So in simplest terms, negligence is basically an omission. A simple case of negligence can be, suppose you're driving the car and there was a red light and you jumped the red light. Now, although violation of traffic rules has been made a criminal offense, that's a different issue. But suppose you jumped the red light and you caused damage to Mr. X. Now, in this situation, it is negligence. It is indeed negligence on part of the defendant. Why? Because had he not jumped the red light, there would have been no damage to the person who was injured. Now, what is also interesting to see here is that negligence under law of torts can only be proved or can only be committed once the three essentials are fulfilled. What are those three essentials? The three essentials are that the defendant must owe a duty of care towards the person. There must be some breach of duty, and the breach of duty has resulted into a damage to the plaintiff. Am I clear? The defendant must owe a duty of care to the plaintiff. The defendant has caused a breach of such duty and it has resulted in damage to the plaintiff. Now the question is, what is duty of care? Now, duty of care is in essence is a responsibility. That means a person owes a responsibility to other fellow citizens. What do I mean by that? We all are individuals, but we all live in a group, which is we call as a society. Now, you're free to enjoy your rights, but does that mean you can enjoy these rights at the expense of someone else? The answer is a no. And there is a very famous saying in law of torts that your right ends where my nose begins. That means you have your rights, but to a certain extent. So every person owes a duty of care. And if you people remember, we discussed in the very first class of legal reasoning about rights and duties. Yes or no? Now, we all have a right, but we also have a duty not to violate someone else's right. Or for that matter, we all have a right, but the other person also has a duty not to breach it. So it is in this sense that negligence has been made a tort. Now, duty of care towards whom and to what extent? Now, do you owe a duty of care to everyone? Yes, class, what do you think? Do you owe a duty of care to everyone? Or only to those people who might get affected by your action? Let's take an example. Let's take an example. Suppose you are driving on a road, you are driving beyond the permissible speed limits. You ended up hitting Mr. X. Mr. X suffers some injury, as a result of which there is a pool of blood on the road. And there is a pregnant lady standing on the sidelines of the road. She sees the pool of blood and then she suffers a miscarriage. Now, in this situation, is Mr. X, that means the person who was driving the car, is liable to pay compensation to the pregnant lady as well? Yes, class. What do you think? Is Mr. X the person, that is the person who is driving the car?
Could you repeat?
Could I repeat? My question is, how can you not hear me properly? My question is simple. Mr. X is driving the car. He hits Mr. Y, as a result of which there is blood on the road. और रोड की साइड में एक प्रेग्नेंट लेडी खड़ी हुई है, उसने उस ब्लड को देखा और वो बेहोश हो गई. Now, the pregnant lady, can she claim any compensation from the driver? No. Why no, Prarthi and Komal?
So because it was not the driver's fault that the pregnant lady was standing there, and the fact that she saw, it does not concern the driver.
Okay. Now let's try to do this from the essentials. Whether the driver owed a duty of care towards the pregnant lady. Is it a yes or a no?
No.
Right? So no. So once there is a no in the first principle itself, that means the second and third principle need not to be checked. Right? So hence, there is no negligence on part of the driver towards the pregnant lady. So this brings us to the question, towards whom? So towards whom means to all those people who are likely to get affected. Now, this principle is known as the neighborhood principle. The word neighborhood does not denote here any geographical limitation or any geographical boundary. What do I mean by that? ऐसा नहीं है कि आपका पड़ोसी, ठीक है, अगर आप रोड पर चल रहे हैं तो जो भी गाड़ी चल रही है वो सब आपके नेबर हैं. ठीक है. Any person who is likely to get affected. Suppose अभी आज होली है, डेफिनेट सी बात है आप लोग क्या कहते हैं उसको, पानी के गुब्बारे फेंकेंगे, somebody is walking on the road, उसके ऊपर गिरेगा, right? Do you owe a duty of care towards that person? The answer is yes. Although होली है इसीलिए कहते हैं बुरा ना मानो होली है, right? So the principle which is necessary to understand here is the neighborhood principle. The neighborhood principle basically states that any person who is likely to get affected by your action reasonably would be considered as your neighbor, and thus you owe a duty of care towards him or her. Now, this principle was announced for the first time, or I would say was developed in the case of Donog versus Stevenson. Now, what happened in the case of Donog versus Stevenson? The plaintiff had gone to a beer bar. He ordered a ginger beer. The hotel gave him the beer, a particular brand of ginger beer. Now, जो beer का जो bottle था, that was not transparent. ठीक है, तो उसके अंदर क्या कंटेंट होगा वो पता नहीं चल सकता था. Now what happened was, उससे पूरा बियर पिया, और जैसे ही उसने लास्ट थोड़ी सी जो बियर बची हुई थी वैसे वो डाली अपने जब ग्लास में, तो उसमें से एक मरा हुआ जानवर निकलता है, राइट? नाउ he sues the company that is the beer manufacturer for compensation. Now what do you think? Is beer company liable? Okay, why? But the beer company owned, did the beer company owe any duty of care towards the customers of a beer bar? So if they don't owe a duty of care towards the customers of the beer bar, then how can they be held liable? Prarthi, isn't it contradictory to your line of argument? Yes. That is something I'll definitely tell you. Who will be liable? I'm just asking you all, what is your opinion? Yes, Komal? Company will be liable for that, Komal. Why company would be liable? मैं एक स्क्रीन पीछे लेके जाता हूँ. Yes. Are all the essentials fulfilled? Now, yes, class. Are all the essentials fulfilled? Okay, fine. Let's take it forward. Suppose, now let's take this example again. Who is manufacturing the beer here? The manufacturing company? Does the beer bar or does the seller has any role to play here apart from serving it to the customers? So who ultimately has the duty? The manufacturer. So this was exactly the case before the court, because ultimately in law of torts, what we have stated, there must be some act or omission. Now that act or omission must be direct, but here it is indirect, but still a person is getting affected by it. So the court ultimately discussed what is now known as the neighborhood principle. Neighborhood principle basically says that any person who is likely to get affected by your action would be considered as a neighbor for the purpose of law of torts. Now, the court held, because the ginger beer or the beer manufacturer is making the beer, he is under our duty to check that his contents or to check that his product is consumable. If it is not consumable, then whose liability it is? It would be the liability of the beer manufacturer only. Am I clear? Let's take another example. Suppose you bought a new iPhone, Apple, and you bought it from store, any store, कोई भी store ले लो, एप्पल के स्टोर से आपने खरीदा और आपने जैसे ही चार्जिंग पे लगाया, सडनली वो ब्लास्ट हो गया. You suffered certain injuries. Now, can you claim damages from Apple or will you claim damages from the store owner? Apple, very right. Why? Because ultimately the seller is nothing but just a retail point to sell the finished product. So in this situation, what would happen? The Apple would be liable. Let's take another situation. Suppose there is a lizard in your Parle-G biscuit. Who would be responsible? The company? because the packaging has been done by the company. Now, let's take up a situation. Suppose you bought a phone for your friend. As a gift on his birthday. सेम एप्पल का फोन आपने उसको गिफ्ट दिया, उससे बेचारे ने खुशी में ओपन किया, ओपन करके ऐसे उसको लगाया, इट ब्लास्टेड. नाउ कैन योर फ्रेंड क्लेम कॉम्पनसेशन फ्रॉम एप्पल? Why yes and why no? Yes, Komal, why yes? Okay, now the answer is that the boy who to whom it was gifted can claim compensation. Why? Because he was ultimately affected. So the ultimate user can also be affected by the product. And that is the reason why the friend to whom it was gifted can also claim compensation. Am I clear? What was it different, Komal? This is the ginger beer case, Donau versus Stevenson. What was different? What was different, Komal? Tell me the difference. That is what the example is. Donau versus Stevenson. It's a very famous case. Ginger beer. Ka. Doesn't matter, the content remains same. Facts ठीक है, ऊपर नीचे हो सकता है. Are you getting it? It remains the same fact. Ginger beer manufactured. ठीक है. Doesn't matter. How is it different? The principle remains the same. Focus on the principle. Facts are not that important. Just remember that this is the ginger beer bottle case. Yeah. So the end user can also claim compensation provided he is affected or she is affected. Now, so this is the principle of duty of care. So we just discussed to whom. That means किसके पास ये available होगा. That means duty of care against whom or towards whom. Now the second question is to what extent. That means to what limit this principle applies. The answer is the standard of reasonable care. Now, what is reasonable care? The reasonable standard of care, that is the general standards that you expect. Now, let us understand it from an example of a roadside dhaba versus a 5-star hotel. That what is the standard of care? When you are eating at the roadside dhaba, what is your expectation of hygiene? Very low. So if you have suffered, for example, आपने शाम को पानी पूरी खाई और उसके बाद आपको डायरिया हो गया. आपने एक रोड साइड में जो ठेले खड़े रहते हैं वहां से खाया, तो क्या ये नेग्लिजेंस में आएगा? द आंसर इज नो. व्हाई? बिकॉज जब आप ऐसी जगह से खाएंगे सो डेफिनेट सी बात है उसका स्टैंडर्ड ऑफ केयर बहुत ही लो होगा एंड हेंस ही वुड नॉट बी हेल्ड गिल्टी. बट ऑन द अदर हैंड, if you're eating in a 5-star restaurant or you're staying in a 5-star hotel and you're eating there, what do you expect? You expect the utmost hygiene and utmost care. The chances of being wrong are very low, very limited. So वहां पर मान के चलिए अगर आपके खाने में एक पिन भी आ जाती है, स्टेपलर की पिन जो होती है, then also you may claim compensation. So the standard of care would vary. Am I clear with the standard of care test? So suppose मान के चलिए आप एक मेडिकल डॉक्टर के पास गए और उसने बिना देखे आपको कुछ मेडिसिन दे दी. कैन ही बी हेल्ड गिल्टी? Yes, very right. Now, what would happen in the case where you got yourself checked from a Jhola Chhap doctor, basically a doctor without a degree, and then you suffer some injury? Then what would happen? The Jhola Chhap will not be guilty. Why? Because the standard of care is very low, and you yourself have taken that risk. Now, this brings me to another concept which is called as caveat vendor and caveat emptor. Caveat emptor means let the buyer beware, and caveat vendor means let the seller beware. जहां पर स्टैंडर्ड ऑफ केयर हाई रखना है आपको, वहां पर caveat vendor अप्लाई होगा. That means the seller should be aware. An example of this could be understood from a situation. Let's take two examples. Suppose आप मेडिसिन खरीदने जा रहे हैं. अगर मेडिसिन आपको एक्सपायर्ड दे दी तो गलती किसकी मानी जाएगी? आपकी, दैट मीन्स द बायर, या फिर सेलर की? सेलर की. Why? Because he is practicing a specialized function. मेडिसिन का शॉप बेचने के लिए आपको एक लाइसेंस लेना पड़ता है, and then only you can sell, and you have to have certain degree as well. I guess it's called as B Pharma. So the standard of care is very high there. But on the other hand, मान के चलिए आप दूध लेने गए, जो दूध के बूथ्स होते हैं डेयरी, और वहां पे उसने एक्सपायर्ड दूध दे दिया. वहां पे रिस्पॉन्सिबिलिटी किसकी ज्यादा है, आपकी या दूध वाले की? There the buyer has more responsibility. ठीक है, because the standard of care वहां पर कम है in comparison to a medicine store. I hope I am clear with the standard of care and with the duty of care. Am I clear, class? ठीक है. And then I have written a statement which says more the risk, more the duty of care. That means जहां पर रिस्क ज्यादा है किसी इवेंट को करने में, मतलब किसी एक्ट को करने में, वहां पर आपकी ड्यूटी ऑफ केयर भी हाई होनी चाहिए. That means what? जब आप एक ऑपरेशन करवा रहे हैं हार्ट का फॉर एग्जाम्पल, तो डेफिनेटली बात उसमें रिस्क ज्यादा है, तो ड्यूटी ऑफ केयर जो है वो भी आपको ज्यादा लेनी पड़ेगी. दैट इज द रीजन व्हाई स्पेशलाइज्ड हॉस्पिटल्स चार्ज सो मोर. Am I clear? Am I clear with negligence? Because negligence is a very important topic, and every year there has been one or two questions. Okay. Then comes a doctrine called as doctrine of res ipsa loquitur. What is doctrine of res ipsa loquitur? The term res ipsa loquitur translates into things speaks for itself, which basically means कि there are situations where things speak for themselves in such a way that no other conclusion is possible. For example, एक रोड है, उस रोड पर केवल एक ही मकान है और उस मकान से एक फ्लावर वॉज गिरता है जो कि मिस्टर एक्स के सर पे गिरता है. क्या यहाँ पर two conclusion possible? Is there any possibility that the flower was may have been fallen from some other flat or some other premises? The answer is a no, right? And when no two conclusions are possible, then the falling of the flower was clearly establishes that it has fallen from this particular flat or house, and hence it would automatically be considered as a negligence. Yes or no? Then comes contributory negligence. Contributory negligence is a type of negligence. Now, negligence is actually divided into two categories: contributory negligence and composite negligence. What is contributory negligence? Contributory negligence is basically a situation where both the plaintiff and the defendant are at fault and have attributed and have contributed to the damage that has been caused to the plaintiff. A simple example: the driver was driving his car at speed more than the permissible limits within the city, and the plaintiff crossed the road when it was green light, so basically when he was not supposed to cross the road. Now in this situation, there is a negligence on both part. Yes or no? That is where contributory negligence comes into play. Now when there is a contributory negligence, what happens is it ends up holding both plaintiff as well as the defendant liable, and then it helps in reduction of the compensation. Now, what is the ultimate purpose of law of tort? The purpose of law of tort is to put the person into the same position as he was before the accident or the tort happened. So you do it by making the payments of the damage that has been caused. अब दोनों की गलती तो ऐसा तो होगा नहीं कि 50-50 कर देंगे कि भैया 100 रुपए का नुकसान हुआ है, 50 रुपए तुम दो, 50 रुपए मैं भरूंगा, because that is maths and law is not maths. So in law, what happens, what is to be seen is the doctrine of last opportunity. What is doctrine of last opportunity? Doctrine of last opportunity says who had the last opportunity to avoid the accident. ठीक है? That means the person who has the last opportunity to avoid the accident would be held more responsible. right? So this is what the doctrine of last opportunity is. Now, example of last opportunity. I just give you an example. Suppose I was driving the car and then there is a, okay, ठीक है, doctrine of last opportunity का example, ठीक है. So suppose there is a train that's coming and you, instead of stopping your bus or stopping your vehicle, crosses the crosses the what do you call it, railway crossing. Now, in this situation, what would happen? The person who has the last opportunity, the person who is actually crossing the railway or is actually crossing the railway crossing has the last opportunity. So he would be more responsible for the damage that has been caused. And we are assuming for the example that there was some negligence on part of the railways as well. For example, उन्होंने railway crossing को बंद नहीं किया या signal गलत दे दिया. ठीक है? Is it clear? Just any doubt, any confusion? The last topic with respect to negligence is composite negligence. Just read and explain this to me. Contributory समझ में आ गया? अब बताइए मुझे composite क्या कह रहे हैं? ओके, कॉम्पोजिट कॉन्ट्रीब्यूटरी नेग्लिजेंस में क्या हो रहा था? एक प्लेंटिफ है, एक डिफेंडेंट. ऑन द अदर हैंड, कॉम्पोजिट नेग्लिजेंस में क्या हुआ? एग्जैक्टली, वेरी राइट कोमल. दो लोगों ने मिलकर तीसरे को नुकसान पहुंचा दिया. सपोज दो कार आ रही थी, दोनों ही नेग्लिजेंटली ड्राइव कर रहे थे। देन दे सॉ ईच अदर, और उनको लगा कि वो दोनों गाड़ियां बड़ी, तो उन्होंने क्या किया, ब्रेक्स लगाए, और ब्रेक लगाए तो गाड़ी जो थी वो स्वेल करी, मतलब घूमी, और साइड में जो पान की दुकान थी उसमें जाके दोनों गाड़ियां भिड़ गई। हु इज द डिफेंडेंट? बोथ द कार्स। नेग्लिजेंस किसका है? कॉम्पोजिट है दोनों का, अलग अलग। इज इट क्लियर? नाउ the next topic is nuisance. Nuisance is again a very important tort. Nuisance is a tort committed against immovable property. Nuisance is defined as any unreasonable or unlawful or unjustifiable interference with the use or enjoyment of land or property and any right associated with such land or property. Which basically means that when a person causes interference with the rights that are associated with the land, then it would be a case of nuisance. A simple case could be, for example, I'm playing loud music in my house at I'm playing loud music at my house in my house at 12 in the night. So the person who lives next to my house is getting disturbed. This is nuisance. Yes or no? Right. So nuisance basically creates a restriction on your freedom, right? So nuisance and your right to freedom would always be in contradiction with each other. And that is the reason why freedom is always reasonable. That means there are reasonable restrictions attached to freedom. Now, under law of torts, private nuisance is covered, whereas public nuisance is covered under the Indian Penal Code as a crime. Okay? I'll get into the distinction of the two. Now, let's take an example. Suppose I'm cooking food in my kitchen. And for the sake of example, let's assume that I am a non-vegetarian and I am preparing fish. I'm cooking fish. Now, fish has a very pungent smell, and the fumes travel to the person who lives above my house into his home, which is a completely vegetarian family, and they get affected by it. Like they cannot withstand the smell of the fish curry. Now, can they claim nuisance? That means जो ऊपर रहते हैं who are getting disturbed by the smell of the fish curry. Prarthi says yes. Yes, Komal, what do you think? Okay. Prarthi, is it unreasonable to cook non-veg for yourself? So what is the definition? Unreasonable, unlawful, or unjustifiable, right? None of the three are fulfilled. So definite सी बात है, cooking food, even though it may be very smelly, it may have some sort of issue, you may have some sort of issue with it, but still it would not be considered as nuisance. Now let us assume, let's change the situation a bit. Suppose I'm running a student mess from the same premises, same example hai. And now as a premises, I'm cooking non-veg food for my clients, for my customers, and now my upper wala is getting disturbed. Now would this amount to nuisance? You didn't understand the fact. Okay. Same example, वही cooking वाला. अब इस situation में क्या हो रहा है, मैं जो हूँ एक मैस चलाता हूँ, ठीक है, खाने का मैस स्टूडेंट्स के लिए, और उसमें मैं नॉनवेज फूड बना रहा हूँ, उससे फ्यूम्स उठे फिश के, और वो जो है वो ऊपर जाते हैं, और मेरा ऊपर वाला परेशान होता है. नाउ विल दिस बी कंसीडर्ड एज न्यूसेंस? दैट इज व्हाट माय क्वेश्चन इज. Right. The answer is simple. It would, in this situation, be considered as nuisance because you are doing an unreasonable act within a residential premises. Am I clear? Right. Now let's talk about the two defenses. The two defenses that are available in the case of nuisance are extra sensitive plaintiff and acquired or prescriptive right. I'll get into this. First one is extra sensitive plaintiff. What do I mean by extra sensitive plaintiff? Extra sensitive plaintiff is basically a plaintiff who cannot withstand any sort of reasonable interference as well. Suppose मान के चलिए आपके घर में पूजा हो रही है, पूजा हो रही है और उसकी वजह से आप डेफिनेट सी बात है आरती होती है, उसकी वजह से कोई पड़ोसी डिस्टर्ब हो जाता है, कहता है कि भाई ये तो न्यूसेंस है. विल इट अमाउंट टू न्यूसेंस? द आंसर इज नो. Sorry. Why? Because if a person cannot withstand even the basic disturbances that keep on happening in day-to-day life, that does not mean everything that one cannot withstand would be considered as nuisance. Now, suppose you are conducting music lessons in your home. आपने म्यूजिक की क्लासेस चालू कर रही है अपने घर में. Your neighbors are getting disturbed of this. Will it be considered as nuisance? Yes, class. Okay. If your neighbors are getting disturbed of music classes, so what do you think it is? The answer is simple. It would be nuisance. Why? Because you cannot run music classes in your home. Let me change the situation a bit. कैन यू रन म्यूजिक क्लासेस इन योर होम? मेरा सिंपल सा सवाल है, क्या आप म्यूजिक क्लासेस अपने घर में चला सकते हैं? यस, नो, लीगली नो। म्यूजिक क्लासेस नॉट, मतलब मैं म्यूजिक क्लास देने नहीं आ रहा हूं एक इंसान को, आई एम रनिंग अ म्यूजिक स्कूल बेसिकली। अंडरस्टूड। सो ऑब्वियसली बात है ना, आप अपने घर में अगर कल की म्यूजिक क्लासेस कैसे चलाएंगे? नो, म्यूजिक क्लासेस की अगेन ना कमर्शियल एक्टिविटी है, तो यू हैव टू रन इट इन अ कमर्शियल थिंग। ना सपोज मैं अपने घर में प्रोजेक्ट बना रहा हूं एंड आई एम टाइपिंग, ठीक है, अकेला, मतलब जो स्कूल के प्रोजेक्ट्स होते हैं या कॉलेज के प्रोजेक्ट्स होते हैं, आई एम राइटिंग, आई एम मेकिंग वन ऑफ द प्रोजेक्ट्स, and my neighbor is getting disturbed because of the typing, because of the sound of the keyboard. That, yeah, yes, Komal, you raise your hand. अच्छा, बाय मिस्टेक, ओके। तो उस सिचुएशन में क्या होगा? जब मैं टाइप कर रहा हूं और मेरा पड़ोसी उसकी वजह से डिस्टर्ब हो रहा है, विल इट स्टिल अमाउंट टू न्यूसेंस? No. Why? Because if somebody cannot even withstand the sound of typing, then there is a problem in him or her, right? So that is what is the case of extra sensitive plaintiff. The second defense is that of acquired or prescriptive right. Now, what is an acquired or prescriptive right? These are cases where an activity is done continuously over a reasonably long period of time, and as a result of it, it become lawful. Now, the general rule is if an activity is continued for 20 years, supposedly, then it becomes a reasonable activity. Let me take an example. Suppose मैं एक residential area में रहता हूँ, उस रेजिडेंशियल एरिया में एक मोटर गैराज है, ठीक है, मैकेनिक की शॉप है। तो आप सबको पता है मैकेनिक की शॉप में बहुत ज्यादा शोर होता है, ठीक है, गाड़ियां आती हैं, सफाई होती है, और क्या कहते हैं, सही भी होती हैं। सो देयर इज अ लॉट ऑफ मेटल साउंड दैट इज मेड देयर। नाउ इस सिचुएशन को समझते हैं जरा। कोई, तो वो मोटर गैराज जो है वो पिछले 25 साल से चल रही है। Now, in the 26th year, can suddenly people come and say, now this is a nuisance and you have to shut down your shop? Is it right? No. Right? That is what is called as acquired or prescriptive right. That means if an activity, even though unreasonable, unjustifiable, is continued over a long period of time, the person doing so would acquire a right to continue with it. Am I clear? Now, मान के चलिए कोई एक्टिविटी पिछले 20 साल से चल रही थी। इन द 21st ईयर व्हाट हैपेंड? अ न्यू फैमिली कम्स इनटू द सोसाइटी। नाउ कैन दे फाइल अ केस ऑफ न्यूसेंस अगेंस्ट द कार मैकेनिक? शॉप ओनर. Prarthi says no. Komal, what is your view? He cannot claim. Why? वो तो अभी आए हैं सोसाइटी में, तो उनको तो 20 साल हुए ही नहीं है देखते हुए. फिर राइट, वेरी राइट. सो अगर आप सोसाइटी में नए आए और वहां पर कोई ऑलरेडी एक्टिविटी चल रही है 20 साल से या रीजनेबली कंटिन्यूअस लॉन्ग टाइम से, तो उस सिचुएशन में वो जो इंसान है जो कि शॉप चला रहा है, he has a better right over your right. Am I clear? So अगर आपको आना था तो आपको पहले ही से चेक करना चाहिए था कि क्या ऐसी एक्टिविटी तो नहीं हो रही है जिसकी वजह से आप परेशान होंगे. ठीक है, सो इट इज योर ड्यूटी टू चेक. एम आई क्लियर? एम आई क्लियर विथ प्राइवेट न्यूसेंस? Very right. Then comes public nuisance. Now, public nuisance is a crime, as I already said. Now, what is the case of public nuisance? Suppose there is a road block. ठीक है, पूरा रास्ता जाम हो गया है कुछ एक्टिविटी की वजह से, इतने सारे लोग अफेक्ट हुए, तो क्या उस सिचुएशन में क्या हुआ? इट इज अ क्राइम. व्हाट इज क्राइम? क्राइम इज अ crime against the whole society at large. ठीक है, तो पब्लिक न्यूसेंस को इसलिए क्राइम बनाया गया क्योंकि इट अफेक्ट्स द सोसाइटी एट लार्ज. तो जब पब्लिक न्यूसेंस का केस होगा उस सिचुएशन में प्राइवेट न्यूसेंस नहीं हो सकता, एक्सेप्ट इन वन सिचुएशन जहां पर यू हैव सफर्ड एन एक्स्ट्रा डैमेज व्हिच नो वन एल्स हैज सफर्ड. लेट मी गिव यू एन एग्जांपल. सपोज एक सिचुएशन लेते हैं, मान के चलिए एक जगह पे रास्ता जाम हो गया क्योंकि लोग धरना प्रदर्शन कर रहे थे. न्यूसेंस हो गया, आपको ऑफिस पहुंचना था, आप ऑफिस टाइम पे नहीं पहुंच पाए. क्या आप अलग से कोई केस फाइल कर सकते हैं क्लेमिंग डैमेजेस? यस क्लास? Can you repeat? Okay. My question is, suppose चक्का जाम हो गया, रोड ब्लॉक हो गया उस जगह, तो डेफिनेट सी बात है रोड ब्लॉक है तो लोग जा नहीं सकते वहां से, क्योंकि रोड ब्लॉक हो गया. सो यू वर गोइंग to your office, ठीक है, and because of the roadblock you had to take a detour, आपको दूसरा route लेना पड़ा, and that is the reason why you reached your office late. Now, can you claim compensation as that nuisance has been caused? Okay. The answer is no. Why? Because there is no extra damage that has been caused to you. You have not suffered some any extra damage which everyone else has suffered. भाई बाकी जो लोग ऑफिस जा रहे थे वो भी तो लेट हुए होंगे उस दिन, क्योंकि उनको भी अलग रास्ता लेना पड़ा. Right? Am I clear? दूसरा, प्राइवेट न्यूसेंस होगा कब? प्राइवेट प्रॉपर्टी पर. कैन इट एवर हैपन इन अ पब्लिक प्रॉपर्टी? Yes or no? Right. Let's take another example. Suppose public nuisance का केस है, रोड ब्लॉक हुआ, सारी चीजें हुई, आपको एक मीटिंग में जाना था और मीटिंग करनी थी रतन टाटा से, एंड बिकॉज यू गॉट स्टक इन द ट्रैफिक जैम बिकॉज वहां पर रोड ब्लॉकेड था, रतन टाटा जी चले गए और आपकी मीटिंग नहीं हो पाई. और अगर वो मीटिंग हो जाती देन यू कुड हैव गॉट अ help of some like 10 crore rupees for example. Now, can you claim compensation because you have suffered some special damage? Is it a case of private nuisance as well? Yes, class. The answer is no, Komal. क्योंकि अगर आप पहुंच जाते तो आपकी मीटिंग हो जाती, और मीटिंग हो जाती तो शायद पैसा मिलता. देयर इज नो डैमेज दैट हैज बीन कॉज्ड. देयर इज नो स्पेशल डैमेज दैट हैज बीन कॉज्ड टू यू. Am I clear? Right? So again, no nuisance, no private nuisance. Let's take a situation. Suppose Mr. X जो हैं, उनके फादर की तबीयत बहुत ज्यादा खराब हो गई है, और वो एम्बुलेंस में है और रोड ब्लॉकेड है, सेम सिचुएशन है, और रास्ता नहीं दिया गया उनकी एम्बुलेंस को निकलने के लिए, एंड हिज फादर died on the spot in the ambulance. Now, can Mr. X claim compensation for the loss of life of his father in the same situation? Prarthi says yes. Yes, Komal? Yes. Why yes? Explain. Give me reason. Yes, डैमेज तो हुआ, ठीक है, डैमेज तो बट सभी को हुआ है, कुछ ना कुछ, कुछ ना कुछ. Father dies, father died. Okay. So there is a special damage that has been caused to Mr. X, and hence the reason he can claim compensation, even though it is a, I understand, Komal, don't worry. Hence the reason you can claim compensation, even though it is a case of public nuisance. Am I clear? Okay. Did we do the tort of detenue? Have we done tort of detenue? Detenue कर लिया ना, ठीक. Because I was getting confused कि कहीं ऐसा ना हो मैंने छोड़ दिया हो. ठीक है, हो गया, ठीक है. Right. Now we are moving to the next topic, which is called as no fault liability. Now, as a general rule, what we have learned here till now, nervous shock is remaining. ठीक है, तो मैं पहले nervous shock करवा देता हूँ, then I can take the liabilities in the next. So nervous shock is छोटा सा topic. ठीक है, I'll take this first. What is nervous shock? Nervous shock is basically a situation where a person has suffered a mental trauma as a result of the direct consequence of the negligent act of the defendant. What does it say? Shock to the conscience of the person. The shock must be foreseeable. Shock must be a direct consequence of the negligent act and it is reasonably foreseeable. Now, तीन चीजें हैं. Shock is a very huge word. Why? Because shock means आपको धक्का लगा एक तरीके से, इमोशनली, मेंटली. और जो शॉक लगा आपको उसमें और जो कॉज था शॉक का उसमें डायरेक्ट कनेक्शन है. एंड डायरेक्ट कनेक्शन कैसे? दैट मींस इट मस्ट बी रीजनेबली फोरसीएबल. Now, let's take an example. Suppose you are driving a car और आपने एक एक्सीडेंट कॉज किया. उस एक्सीडेंट को देख के पड़ोस में एक बूढ़े अंकल खड़े हुए थे, उनको हार्ट अटैक आ गया. Will it amount to nervous shock? No. Voice is lagging. Suppose you are driving Komal, you cause an accident. जिसका एक्सीडेंट कॉज किया वो मर गया. ये एक पड़ोस में अंकल खड़े हुए थे, उन्होंने देखा और उनको नर्वस शॉक लग गया. Can you be held guilty for causing nervous shock to the old uncle? No. Why? Because there is no direct link between the shock and the. Exactly, very right, Prarthi. Duty of care does not exist. Now, suppose in the same car, मान के चलिए आप ड्राइव कर रहे थे, आपने एक्सीडेंट कॉज किया. जिस गाड़ी का एक्सीडेंट कॉज किया वो ओला की कार थी और उसमें एक पैसेंजर था. तो गाड़ी का एक्सीडेंट हुआ, ओला ड्राइवर की डेथ हो गई और इसको देखकर जो पैसेंजर था उसको नर्वस शॉक लग गया. नाउ कैन यू बी हेल्ड रिस्पॉन्सिबल टुवर्ड्स दैट पैसेंजर? यस क्लास, इज माय क्वेश्चन क्लियर? आपने एक एक्सीडेंट कॉज किया. एक्सीडेंट जिसका हुआ वो ओला वाली कार थी. ओला की कार में एक पैसेंजर और बैठा हुआ था. एक्सीडेंट हुआ तो जो ओला का ड्राइवर था उसके सर में चोट लगी और खून फैल गया और इसको देख के जो पैसेंजर बैठा हुआ था वो बेहोश हो गया. ही सफर्ड अ नर्वस शॉक. नाउ कैन यू बी हेल्ड रिस्पॉन्सिबल फॉर नर्वस शॉक टुवर्ड्स द passenger. Why no, Komal? Sorry, yes. Okay. Yes, the answer is yes. So, does it matter that कुछ relation होना चाहिए? No. What is necessary is that there must be some forcibility and there must be some causal link between the act and the damage. ठीक है? Now suppose एक एक्सीडेंट होता है, एक बच्चे की डेथ होती है और जहां पर डेथ हुई वहां से 100 मीटर की दूरी पर उसकी माँ खड़ी हुई थी और उसकी माँ ये देख के बेहोश हो जाती है. कैन यू बी हेल्ड गिल्टी फॉर कॉजिंग नर्वस शॉक टू द मदर? Hmm. Yeah, you caused the accident. A person died. The mother was standing at some 100, 200 meters away from the scene of the crime. She suffers the nervous shock. Can you be held guilty? Is it reasonably foreseeable? Okay. Now, here, what is interesting, important to understand is the distance. It is 200 meters away from the scene of the crime. Right? So it cannot be reasonably foreseeable कि 200 मीटर दूर किसी को दिख जाएगा और वो उसकी माँ होगी और उसी बच्चे का एक्सीडेंट होगा. It becomes too remote. ठीक है? That is the reason why it cannot be held guilty. Sorry, that is the reason why Mr. X cannot be held guilty for causing nervous shock. Am I clear? Just because try and understand it from this perspective, irrespective of that, Prarthi, still, just because it was her son, that does not put her into a more important position. Because हम जब ओला ड्राइवर वाले केस में पैसेंजर के केस में नर्वस शॉक होल्ड कर रहे हैं, दो देयर एग्जिस्ट नो रिलेशन, right? But it is reasonably foreseeable that if an accident has been caused, then the co-passenger can get nervous shock. But a person is standing 100 meters away and still getting nervous shock, that is too remote. Then in that situation, सोचिए, मान के चलिए कोई वहां से देख ले और कोई फोन कर दे, मम्मी उसकी अमेरिका में रहती हैं और उनको अमेरिका में नर्वस शॉक आ गया, फिर या वो वीडियो कॉल कर रही थी, ठीक है, और उसी टाइम एक्सीडेंट हुआ और उन्होंने वीडियो पे देख लिया सब कुछ, देन except vision, what do you, can you give me an example?
Yes sir, like इसी केस में for example you said that किसी ने उनको कॉल करके बोला, तो अगर she experiences a nervous shock by the मतलब वो सुन के, so will we be liable for that?
No, no, too remote.
Okay.
That is exactly what I'm saying. It would be too remote. Similarly, suppose she was on a video call with the son, right? And in the video call, she saw somehow the accident. Then exactly. So you need to understand the reasonableness. Reasonableness कैसे होगा कि कुछ direct link हो. Otherwise किसी ने कुछ भी किया और डेफिनेट सी बात है बहुत ही सैड अनफॉर्चुनेट इवेंट्स होते हैं एंड समटाइम्स यू नो योर पेरेंट्स योर रिलेटिव्स do get affected by it, but can we held every such situation to be a case of nervous shock? Then there would be no stopping, right? कहीं ना कुछ reasonableness तो लानी पड़ेगी ना. That is the reason why there must be a direct link. Right. So we'll stop here today. In the next class, we'll start with no fault liabilities, which is strict liability, absolute liability, and vicarious liability. Okay, and then we'll be completing our law of torts. Probably in a class or maybe in one class or two class, we'll be completing law of torts. Fine. That's all from my side. Thank you. Happy Holi.